just a couple of quick things to mention, and then I'll turn it over to our speaker today. First, if anybody would like a program card, these are our programs for the entire year. So we've got the schedule going through November. A lot of good options, covering different aspects of Milford history. And so I'll put those over there on the table, so you can grab them. The other thing we've got, this is very exciting, every year the Historical Society puts out a calendar that the Bank of Millbrook very graciously prints and distributes. And so these are available at the bank normally, but we have a handful of them here today. We've been doing this for 27 years. It's the 27th version of this. It has photographs from Historical Society, from the archives. Usually the calendar has a theme. The theme for this one is parades. Everyone loves a parade. David Greenwood, Nan Greenwood are instrumental in putting this together, so thank them for doing this. You've been involved all 27 years of this? Right, from the start. And so I have these calendars. Kids, you want a calendar? Can you fit this in your locker? Does anyone use lockers? No. This is way better than anything on your phone. All right. Our guest speaker today, we're so excited to have him. It's Mark Dillon. I actually taught his son at Arlington High School a number of years ago. And I guess I talked about the Millbrook Historical Society so much in class back then that he went home and told his father about it. And so when Mark wrote this new book, The First Chief Justice, John Jay and the Struggle of a New Nation, which came out in the fall, he reached out to us to say he'd love to come and give a talk about the topic, and perfect. And so he's here tonight. He is a New York State Supreme Court Justice, Appellate Division. Yes. Correct? And he spent years researching John Jay, of course, right, as a judge, First Chief Justice. And so we're going to hear about John Jay. We're going to hear about his connection specifically to Dutchess County a little bit, look at some images. There'll be time for questions at the end, but I will turn it over to Mark. Thanks for being here.
Thank you very much. So I gather that a lot of you here love history as much as I do, because it's the only way to explain that you would leave your homes on a cold, rainy, dank January night to be here. But this side of the room, I gather you're here because you have to be. Extra self-interest. Extra credit.
Yeah.
That's wonderful. We're going to talk about John Jay tonight. We know that in Dutchess County, just down in Fishkill, we have John Jay High School. It can't be anything like Arlington High School, but maybe a close second, right? And we'll touch upon the fact that that high school is there, and it's named for him because that's around the area where he lived in Fishkill for part of his life. But we'll talk about that. John Jay was a founding father in the state of New York. He's the one founding father that doesn't have a Broadway musical named after him. But maybe they could maybe they could have done that. So I'm going to talk a little bit about his life, about how his life led him to a career in law, how his career in law led him to a career in politics, and about how his career in politics led him to being our first Chief Justice of the United States Supreme Court in 1789. The book, and I'm not really here to talk about the book, I'm here to talk about Jay. But the book is the first of its kind in our 230-odd years history. Jay is the subject of either biographies, some of them very good, or he's a character that floats in and out of the general history books about the times in the 1760s and 1780s, 70s and 80s and 90s. But there has never been a book that looked primarily at the 6 years that he spent in his life between 1789 and 1795 as the first Chief Justice of the United States. And I think the reason for that is that a lot of historians, they look at the political things. And then when Jay becomes Chief Judge, he goes into this monk-like experience of deciding cases, but that's not, to a lot of historians, what's really interesting about the politics of the time and the history of the time. So what the book does is it takes the 11 cases that were decided by the United States Supreme Court during those 6 years. 3 of them were the same case, kept coming back, so there were really 9 cases. And of those 9 cases, there were 3 of them which were very inconsequential minor matters or really very little interest or import to history. So you're left with 6 cases. And those 6 cases each have a separate chapter in the book about things that were happening before, during, and after the cases themselves, and how those cases were decided, and how they have affected the law that has followed in all the years, the centuries later. But to understand the cases, you have to understand John Jay and how things that happened in his life and his career and his politics affected how he later saw the law and decided those cases. So we're going to focus tonight mainly on Jay the person. He was born on December 12th of 1745 down in Lower Manhattan, not far from the Trinity Church, if you know that landmark, down by Wall Street, near where the World Trade Center used to be. And his mother was a Phillipstown, in Putnam County. He also was related through his mother to the Van Cortlandt family. Well, we know of the town of Cortlandt in northern Westchester between Yorktown and Peekskill. And his father was a merchant who did a lot of transatlantic trade with Ireland, Britain. He was one of 8 children. The family had a number of tragedies early in his life. 2 of his siblings died during the first few days of their lives. Another sibling died at age 3. One sibling was mentally disabled. One sibling was emotionally disabled. The family was Episcopalian, which I'm told is the Americanized version of the Anglican Church. And when Jay was a very young boy, about 5 years old, his merchant father decided that he was going to retire from the business, didn't need the money, and move from Manhattan to Westchester County. The family bought a 400-acre estate in Rye, New York, within view of the Sound shore, and across the shore was the northern shore of Long Island. And Jay had a very privileged upbringing. He was homeschooled for some years. Then he went off to boarding school in New Rochelle, which was nearby. And then he went to King's College in Manhattan, which at the time was an Anglican, Episcopalian school of higher learning. But King's College is now known as Columbia University, so that's the roots of the school. In those days, most people didn't go to college. You couldn't afford college. They didn't have guaranteed student loans like today. They didn't have needs scholarships. You went to college if you came from a family of means that could afford the tuition, the room, and the board. The family, the Jay family, when they moved to Westchester County, they did own slaves. Now you can't excuse that, and you can't say that by definition, if people work for the family as slaves, that anyone was treated well, by definition. But compared to how slaves were treated in other parts of the country, particularly the South, there was a very humane, within the confines of what slavery was, which again we can't excuse, the people that were indentured as slaves to the Jay family were treated humanely for the time. When Jay's father retired from being a merchant, he was owed 4,000 British pounds. There's different ways you can compute what that might be worth today, but we're talking roughly about $1.2 million. And the father had to go to the courts, in order to the colonial courts, in order to collect that money. And over the course of about 4 years, he collected about 90% of the money that he was owed. Young Jay, John, knew of that family history. So when he later became a lawyer, he handled a number of debt collection cases. When he later became a judge, there were a lot of debt collection cases in the courts. Jay was very sympathetic to creditors who were owed money by debtors. This might have tied in a little bit with his religious upbringing too, that people be responsible for themselves. And skipping forward even more, he had been a negotiator of the Treaty of Paris, which officially ended the war between the United States and Great Britain. And one of the things that was in that treaty was a provision that each country allow the creditors of the other country to collect monies in the courts. So this is one instance where we can see that something in Jay's childhood affected his viewpoint of a legal issue that he would see as an adult in the courts. So he graduated from King's College in 1764. Back in those days, and I don't know if we have any lawyers in the group, but back in those days, there was no such thing as a bar exam like what we have today for law school graduates to become attorneys. Instead, what you did, in fact, there wasn't even such thing as a law school. A little later, William and Mary became the first college to have a major in law, but that even wasn't a law school. So what people did instead is you interned for 5 years for an established attorney. And assuming that you did that work to the satisfaction of the lawyer that you worked for, that lawyer would then go to his colleagues, and I say his because there was no such thing as female lawyers at the time. He would go to his colleagues and he would vouch for the intern and say, this is now somebody that has worked for me long enough and well enough that he can be an attorney in his own right. So John Jay interned for a very established attorney by the name of Benjamin Cassam. Benjamin Cassam did legal work for some of the most established families in the New York colony. One of the cases that Cassam worked on was the Dutchess County rent riot trials. The Indians had a lot of land in Dutchess County. And the Phillips family, I mentioned the Phillips family before, the Phillips family claimed right, title, and interest to that property by virtue of certain land grants. That matter had gone into the courts. The Phillips family won, no surprise. The Wappinger Indians lost. And once the Phillips family truly had legal title to that property in Dutchess County, they raised the rents on the tenant farmers that would farm the property in order to make the property profitable for themselves and for the owners. The problem is that the Phillips family raised the rents so much that it was impossible for the tenant farmers to really eke out a living with those rents on the property. And that prompted the Dutchess County rent riots. Governor Moore, who lived in Manhattan, he was a colonial governor, sent troops from Manhattan up to Dutchess County to put the riots down. Some of the troops were killed, some of the rioters were killed, a number of other rioters were arrested, and they were tried in the King's Court, in the original Dutchess County courthouse in Dutchess County. A judge by the name of Horsman was the judge of the trial. William Pendergrast of Pauling, New York, was the titular leader of the rioters. He and others were found guilty, but because Pendergrast was considered to be the leader, his sentence was one of death. He was to be drawn and quartered, and just for extra good measure, beheaded. His wife was a woman by the name of Mehitable Wing. Jay was working on this trial, incidentally, with Benjamin Cassam. Mehitable Wing took a horse and rode virtually nonstop from Poughkeepsie down to lower Manhattan, found Governor Moore in his pajamas at night, and pleaded with him to sign a temporary reprieve of the death sentence so that a more permanent reprieve application could be made to King George in England. The reprieve was signed, so Mr. Pendergrast was not executed. There were 7 children, incidentally. And ultimately, King George signed off on a reprieve of the death sentence. Once again, John saw, as another influence in his life, John Jay saw how the workings of government, the mercy of the king, can work in favor of what he thought would be a just resolution to the matter involving William Pendergrast. William Pendergrast, incidentally, didn't kill any soldiers. He didn't fire a single shot. He was convicted of something they called at the time constructive murder, meaning somebody else fired the shot, but because he was there, he was just as guilty. So he finishes his internship with Benjamin Kassam and he opens a law practice. The practice that he opened, he had a partner by the name of Robert Livingston, who was a classmate of his. Robert Livingston was the son of a very prominent New York family at the time, the Livingston family of New York and New Jersey. Jay and Livingston opened a law office, and guess where it was? Livingston's father was a New York State Supreme Court judge, so he had judges' chambers. Jay and the son had their law office operating out of the father's judge's chambers. Now imagine how unusual that would sound by today's standard if you had a matter before that judge and the lawyer that you're up against is sharing the same office as the judge's chambers. But things like judicial ethics and legal ethics were different then than they are today. Another example of that was that if you were a high-ranking government official, an attorney general, a governor, whatever, and you also happened to be a lawyer, you were allowed to go into the court representing private clients and supplementing your income in the courts on behalf of those private clients. Maybe the most egregious example was that years later when John Jay was Chief Judge of the United States Supreme Court, there was an attorney by the name of Alexander Dallas. Dallas was also the official court reporter for the United States Supreme Court, taking down the minutes of what was happening and making an official record of what was being done in the court proceedings. There was one case where Alexander Dallas was the court reporter, where he was also at the same time an attorney on behalf of one of the parties that was arguing before the United States Supreme Court. People didn't seem to have a problem with that. Nowadays you can't have a court reporter who might skew the minutes of the proceedings to favor one side or another because they have an interest in it either as a party or a lawyer. So the practice that John Jay had was in Manhattan. He was living in Manhattan at the time. He took a horse 6 miles from wherever it was he lived, we don't really know exactly where he lived at that time, to where the judges' chambers were that he worked. He also had cases in Westchester County, some cases in Queens, and cases in Dutchess County, at the Dutchess County Courthouse in Poughkeepsie. There was no Putnam County yet. That didn't become established until 1812. And in order to get around to these various courthouses, he would have to travel by horse on a night like tonight, in the rain, in the cold, or in the snow, or in the heat of the summer. They didn't have air-conditioned cars, they didn't have Metro North, they didn't have the Staten Island ferry. He didn't seem to have any cases on the other side of the river in Rockland or Orange County. He stayed on this side. That might have been as a result of the river itself. It was a bit of a barrier for people. His law practice became very, very successful very quickly. One of the earliest matters that he had is he was hired to be the clerk for what was known as the Boundary Commission. Rockland and Orange County was contested. Jersey thought it was theirs. New York thought it was theirs. And a boundary commission was set up by the British government in order to resolve the disputes. They would look at the land grants, they would look at the records, they would look at a number of things. And eventually they worked out a solution where what we now know as northern New Jersey stayed with Jersey, Rockland County and Orange County became part of New York. And it was another example of Jay seeing how if people reason together, work things out, you can resolve disputes without war, without New York going to war against New Jersey or vice versa. And this informed his years when we were leading up to the Revolutionary War. He was a lawyer. He didn't seem to have much interest in politics at all. And to whatever extent he may have been interested in politics, He was not a rabble-rouser. He wasn't fighting for independence at first. He thought, based on the experiences of his life, you can resolve disputes through the courts, you can resolve disputes through commissions, you can work things out. You didn't have to have some kind of reckless declaration of independence of the American colonies from Britain. As an attorney, he handled a wide variety of matters. Lawyers in those days, they're not like lawyers today. If you have a tax problem, you go to a tax lawyer. If you have a patent issue, you go to a patent lawyer. If you have a medical malpractice, you go to a medical malpractice attorney. Back in those days, lawyers basically took whatever walked in the door. He had evictions, he had defamation cases, he had assault cases, criminal cases, contract cases. He represented the common folk with pedestrian disputes. And that was a great contrast between the patrician, wealthy life that he had over here and the work that he did during the day on a horse to the courts for the folks over there. I think that says something about the man as well. His law practice became so successful that he and Livingston eventually split their practice up. And Jay gave Livingston the Dutchess County cases. Why? Well, because he was living in Manhattan, and the Dutchess cases were the most inconvenient for him to have to handle from Manhattan. And since he had more work than he needed, and Livingston maybe a little less work than he needed, those were the logical cases for Jay to trade off to Livingston. And then Livingston went off with his own practice. The Stamp Act occurred as well around that time. And law offices closed, courts closed, because part of the Stamp Act required people to spend money buying stamps for certain documents that would have to be filed and for certain products that would be purchased. There was a lot of rioting, a lot of controversy about the Stamp Act. What made it really controversial was the first tax that was imposed on the colonies that was internal to the colonies. It didn't have anything to do with transatlantic trade with Britain. But eventually the Brits backed down on the Stamp Act. It was repealed. And once again, Jay saw how government can work things out in a way that is to the satisfaction of the public. So he gets married to Sarah Livingston Jay. That's the Livingston family, a relative of his former law partner and college buddy. And he takes a honeymoon. They honeymoon to the northern reaches of the Hudson Valley. And they come home and they hear about something called the Boston Tea Party. And Jay, being a prominent lawyer, is asked if he could be part of a committee of 100, which they called it, for the purpose of writing a letter that would be on behalf of the colonists of New York in support of the people of Boston. And he gets involved. And not realizing that with that act, he was now being pulled into the political events of the day. And he would never get out for many, many years. This led to the revolution, and Jay was ultimately asked to become the head of an intelligence organization, like what we have today, the CIA. He ran an organization where he had individuals that would go out and infiltrate British groups to find out what the Brits were up to, what were their plans, what towns did they seek to seize, who was involved, who was selling out the American interests. One of the plots that they uncovered was a plot by certain British to infiltrate the security guard that was around General George Washington. The idea was to kill George Washington. They busted that plot up. A couple of people were hung as a result of being caught. It involved the then mayor of the city of New York. And from that day forward, George Washington would be in the debt to John Jay and some others that were around John Jay for busting up that plot. Potentially it saved George Washington's life and altered the course of our early history. So when we fast forward to when John Jay is being considered for possibly a cabinet post in the first Washington administration, after our 1789 Constitution comes in, well, Jay had history as a lawyer. He was qualified. He had spent some time as a chief judge of the state of New York. He was qualified as a judge. But he became the first chief judge, I think, in part, because he knew Washington. Washington knew him. And Jay had been part of the group that saved Washington's life years earlier. But on that point, I digress. He got to know a spy by the name of Enoch Crosby. And he was probably the best spy of the time. And years later, in 1828, James Fenimore Cooper wrote a book called The Spy. And it was based on Enoch Crosby. And Cooper had consulted with John Jay. This was much later in Jay's life when he was in retirement and not long before he died. But he consulted with John Jay about the experiences of Enoch Crosby, and it formed the basis for this book that James Fenimore Cooper had published called The Spy. Eventually, New York and other states declared their independence from Great Britain. New York needed a constitution. They turned to John Jay, this prominent lawyer, this individual who had been supporting the revolution, and they asked, would you write our first state constitution? He said, okay. And he did. And then, when the state was officially established with the Constitution, they needed a first New York State chief judge. Some people wanted him to run for governor and be the first governor. He decided he wouldn't, and with hindsight, that was probably a smart move, because the person that ran for the office and that won, and that Jay would have opposed, was George Clinton. And George Clinton proved to be a very popular candidate. He was in the office for several terms. These were 3-year terms in those days, not 4-year terms. So Jay instead became the first chief judge of the state of New York. Spent about a year in the post. The first court session that he held was in Kingston, at the Kingston courthouse. Eventually, he was asked to go to the Continental Congress on behalf of New York and to try to work out a dispute that had existed between people in New York and people in Massachusetts and these other people up in that area who wanted to start a new state of their own called Vermont. And it was very contentious at the time, and the New York government, Massachusetts government thought, well, if we send some delegates down to the Continental Congress, maybe we can work out some resolution. So Jay goes down to the Second Continental Congress. He's now rubbing elbows with some of the most prominent political figures of the continent. And on day 2 that he's there, a man named Henry Lorenz, who was the president of the Continental Congress, resigns. And they need a new president of the Continental Congress. And there's Jay, all of 28 years old. And he gets elected by the states to be the president of the Continental Congress. This was the closest office that there was at the time to a national executive. We didn't yet have our Constitution. George Washington wasn't president yet. And he spends about a year as the president of the Continental Congress. He's dealing with foreign governments. He's dealing with domestic issues. He's dealing with debt issues, financial issues. Eventually, a decision is made that we need to send somebody with some gravitas to Spain. He goes to Spain. He represents the states before the Spanish government. Meanwhile, the Revolutionary War continues to wage. Eventually, we win some major battles, Ticonderoga, Yorktown, and so forth. And the need is for a treaty between the United States and Great Britain. So Jay, once again, is asked, go to Paris and negotiate a treaty with Great Britain. So he goes to Paris. You're noticing a pattern here. He's asked to do things. Be on that committee of 100. He does it. Go to the Continental Congress. He does it. That Vermont thing didn't work out incidentally. It resolved through other means. Become president of the Continental Congress. He does it. Go to Spain. He does it. Go to Paris. Write the treaty that we need with Britain. He does it. And there are more things that he does, not necessarily because he wanted to, but because he was asked to. He was like a key person that you go to if you need somebody dependable to get something done. So his fellow negotiators were Benjamin Franklin, who for many months was suffering from gout and was a little out of the game. You had Henry Lorenz, the former president of the Continental Congress, who actually had been captured by the British, crossing the Atlantic, and was a prisoner. The Continental Congress, not knowing that, had made him a negotiator, but he was being held in the Tower of London as a prisoner. You had John Adams, who was a bit of a hothead. The last thing John Adams was a diplomat in terms of personality. And he was late getting to Paris. And the one guy you really had there the whole time who had diplomatic capability was John Jay. So eventually they arrive at this treaty. It's resolved in 1783. And he comes home a hero, along with the others, because the terms of this treaty were so favorable to the United States. He was so popular. He was a rock star when he came home. And he expected to come home and go back to the practice of law that he had been neglecting for many, many years. But instead he finds out that the Continental Congress had appointed him to be the Minister of Foreign Affairs for the states during what would be the period of the Articles of Confederation. The office that he would hold would be located on the second floor of a building which was then known as Fraunce's Tavern in Lower Manhattan, which still is in business as a restaurant today. The restaurant is on the main floor. It's the longest serving or existing restaurant in, I'm not sure if it's New York or the United States, but it was in business then, it's still in business now. And he lived across the street. So for the next several years, it was a very, very nice life for him, with his family, his wife, his children. His family was growing, and he worked and he lived within a block of the same location. The Articles of Confederation don't work out very well for the United States, and there's a consensus that something more federalized and continentalist was needed for the states. John Jay contributes to that effort by writing what are now known as the Federalist Papers, articles that were published in the newspapers along with those of Alexander Hamilton and James Madison, extorting to the public the reasons why they should support this new, stronger Federalist Constitution. In those days, the political divisions were between Federalists, which Jay was, and Anti-Federalists. The closest analogy we might have, and this is very, very rough, is we have a Democratic Party today that might believe in bigger government, bigger federal involvement, and a Republican Party that believes in more states' rights and less federal involvement. Well, that's a very rough way of looking at the Federalists and the Anti-Federalists back in those days. And he wrote the Federalist Papers to convince first New York, but they were then republished in other states as well. They were so popular, other states, to ratify the federal Constitution, which ultimately does get ratified in 1789. And that brings us around to the now. George Washington has to pick a cabinet. And the three most important posts at the time were considered to be Treasury, State, Secretary of State, and who's going to be the first judge of the United States Supreme Court. Jay probably could have done any three of those jobs. Maybe not so much Treasury, but certainly State. He had the diplomatic experience. He had been abroad negotiating for us. And he could be Chief Judge because of his legal experience and the time that he had spent as the Chief Judge in New York State. Washington decides to make John Jay the first Chief Judge of the United States Supreme Court, starting a system of courts federally from scratch. Jay had already done that to an extent, starting a state system of courts for the newly formed New York State from scratch. Back in those days, there were 6 Supreme Court judges. Today, there are 9. You would think you would want an odd number of Supreme Court judges, so that if a case comes up and there's a split of opinion, you can have, a 5-person majority and a 4-person dissent. Or in that case, if it was an odd number, whatever a majority and dissent would be, a 3-3 tie is not a reversal of the case. It just leaves the lower court decision as it is. But you can't break a tie if you have an even number of people. But the reason they had 6 judges on the Supreme Court originally was that they had 3, what they call circuits. They had an Eastern Circuit, which was all of New England plus New York. They had a Southern Circuit, which was Virginia on down, and then they had a Middle Circuit, which was everything in between. And the idea is that you'd have 2 Supreme Court judges from each of these 3 circuits. And because the Supreme Court didn't have a lot of cases at the beginning, they would only sit originally in New York, then in Philadelphia, and much later in Washington, D.C. They would only sit in February and in August of every term. And what they would do for the rest of the year was, speaking once again about horses, they would ride horses, and they would ride the circuits. They would also sit as circuit court judges, hearing trials and deciding cases that would come up to the circuit courts from even lower federal courts. And that was a very grueling lifestyle. You're away from your family most of the year. You're on that horse in the worst of weather, the heat, the snow, the cold, the rain. You didn't have Marriotts back in those days. You know, you had inns. But back in those days, you'd share a room, even a bed, with total strangers. The food was hit or miss. And the expenses of all that travel, the judges had to pay out of their own pocket. Jay was paid $4,000 a year to be chief judge, which wasn't bad for the time. The other judges on the court had $3,500 a year, but it wasn't as much as it sounded because they had to spend so much time on their travel, food, and lodging expenses. So a number of people were interested in becoming the first chief judge. And of the people whose names were being bandied about, a number of them could have done a terrific job. I keep going back to, why did Washington select Jay instead of one of these others? And I go back to the fact that Washington knew Jay from way back, and Jay may have saved Washington's life. I think that was part of the equation. Another aspect of the circuit writing was that when the Constitution was first created and ratified by the states, it wasn't really known whether it was going to work very well. And it also wasn't known how solid the people were in support of it. There were a lot of questions, too, about a lot of the meaning of the Constitution. What is this separation of powers stuff, this 3 branches of government stuff? We didn't have any model anywhere else in the world. We were inventing this wheel from scratch. So Washington wanted, and the Congress wanted, the judges to be out on their horses, riding these circuits, meeting people in the cities and the towns and the villages, and getting feedback from them. How's it going? There were no opinion polls in those days for Washington to look at for the mood of the country. But what he did have was people like the judges riding the circuit, and perhaps other people that would report back to Washington about what was on the mind of the population. To be a judge in those days, there weren't really courthouses everywhere. And where there were courthouses, there were no law libraries. So to have any kind of law books to refer to help you decide your cases, you had to bring your own. Whatever the judge brought as they rode around, that was their traveling law library. Which meant you needed not only a horse, you needed a carriage. The first session of the United States Supreme Court was held in Lower Manhattan, a building called the Royal Exchange Building. It doesn't exist anymore. It was February 1st of 1790. There were no cases. Jay appeared not wearing a wig. One of his colleagues was walking to the first session of the court wearing a wig, figuring that would be the tradition. And people in the public, some people out on the ground level were making fun of this guy wearing this wig. How ridiculous he looked. And took the wig off when he got up to where court was being held. And that is kind of an accidental way that we broke from the British tradition of having judges wear white wigs that they still wear today in British courts. The very first case that was ever argued before the United States Supreme Court, a case called Van Stropphorst versus Maryland, was settled. So it wasn't until the court moved eventually to Pennsylvania, 1791, when the first ever case was argued before the United States Supreme Court judges. So let me show you some photographs of some of the people, places, and things that we've talked about. And then we'll open up the floor to some questions. I'm going to start with this photograph. Now, why didn't it go on? You had this up and running before.
So it might have fallen asleep.
Oh, wake up. Sometimes if a mechanical device doesn't work well, if you kick it, it will go on.
Yeah, I think it just needs to.
Okay. All right.
It's coming up.
Slowly coming up on the screen. That is a picture of the home in Rye, New York, where John Jay grew up as a child. That building is no longer standing. Around 1840, it was taken down and it was replaced with a new building that is still in existence, and it is known as the Jay Heritage Center. This gentleman is Peter Jay, who was John Jay's father, the merchant who was owed the $1.1 to $1.2 million when he retired. The Jay papers, the official John Jay papers, are repositoried at the Butler Library of Columbia University on the west side of Manhattan. And among the documents there is this. This is the law license that John Jay received when he became a member of the New York Bar. I'm assuming, I don't know this for a fact, I'm assuming that the rope at the top and the bottom was some system where you could use that to hang it on a wall, but I don't know that for certain.
Do you know who approved the law license?
It was signed in those days by the governor of the colony. Sarah Livingston Jay, John Jay's wife. She only lived into her 40s. John Jay lived to be 87. He spent 27 years as a widower. Jumping to the end of his life, after Supreme Court, he was governor of the state of New York for 6 years. And people wanted him to run for a third-year term. He said, no, I'm finally retiring to my farmhouse in Westchester, the one that's in Katona. And I'm going to spend the rest of my life as a gentleman farmer with my wife, Sarah. So he left Albany, where the capital had moved to by that time. And they moved into that farmhouse on 600 acres in Katona, New York. And Sarah died within a few months. This is Enoch Crosby, the famous spy that John Jay managed through their intelligence organization and who was the basis of that James Fenimore Cooper book, The Spy. This is a painting by an artist, a very famous artist named Benjamin West. It is of the negotiators of the Treaty of Paris, which ended the Revolutionary War. Treaty signed in 1783. You'll notice that the portrait is only about half finished. To the left is John Jay. You also have John Adams, Benjamin Franklin, Henry Lorenz, who was released by the British the day before the treaty was signed from his imprisonment. And then you have John Templeton Franklin, who was the clerk or secretary to the American group and a relative of Benjamin Franklin. The reason that you don't have any Brits in this painting on what would be the right side of it is because they chose not to show up. The individual negotiators of the British government didn't want to be memorialized for posterity as the losers in the painting. This painting can be seen at the John Jay Homestead in Katona, New York, Jay's adult life home, if anyone ever goes down there to do a tour of the house. This is the official portrait of John Jay as Justice of the Supreme Court. Notice what he's wearing. The earliest judges of the United States Supreme Court didn't actually wear robes. These robes, and whatever other regalia that he has on, were actually the regalia that he was given when he received an honorary degree from Harvard University in Boston. So when the decision was made that he would sit for a portrait, not knowing what to wear that would be formal enough and regal enough for such a portrait, he used the Harvard material that he had been given and that he still had. He only sat for the portrait long enough for the drawing of the head, and then a relative of his son sat in for the rest of the portrait. If you go to the New York State Court of Appeals in Albany, which is the highest court of our state, they have one main courtroom in their building, and there is an official portrait of every chief judge of the state of New York. And this portrait is in the center, top, most prominent position as you're standing in the well looking up at the bench where the judges sit. Why? Because he was the first. This is also a copy of an original document that is repository at Columbia University. It is the written oath that John Jay took when he became first Chief Justice of the United States.
Do you know who administered the oath?
Not offhand, I'm sorry. I had mentioned a few moments ago that when judges had to ride the circuits, travel around to their cases, they had to bring their law books with them. This is a piece of furniture known as a barrister bookcase, and perhaps some of you have seen this type of furniture before. If you go to law offices and courthouses today, you may see some furniture that looks just like this, with one exception. The idea of the barrister bookcase was that each of these 5 pieces stacked on one on top of the other and can be disconnected from each other. If you have books in it, such as there, you can take the top stack off and flip it onto its back so the glass front side is facing up. You don't have to take the books out. And you'll notice that in this photograph, there's a handle here, a handle here, a handle here, here, and there's handles on the other side as well.
Never knew that.
So without taking the books out, you can then carry each component by their handles, put it in a carriage, ride to your destination, and then when you're in court, reassemble the pieces without ever having to remove any of the books. When you see this furniture piece nowadays, it's just like that, except for the fact that there's no handle, because there's no longer any need for the handles. This is a photograph of one of 2 barrister bookcases that John Jay actually knew or used and owned when he was on the United States Supreme Court, and it is kept at the John Jay home in Katona, New York, and you can see it if you go on a tour there. This is a photograph of the Royal Exchange Building in Lower Manhattan, which I had mentioned no longer exists, but it's the location of the first session of the United States Supreme Court ever on February 1st, 1790. It's where the decision was made not to wear the wigs. Maybe one or two more. Leonard David Barnes. We haven't talked about it, but the very first ever argued case at the United States Supreme Court, which resulted in a decision by that court, was argued by this man, graduate of Harvard College. This is a photograph of what was called Government Building, and I'm referring to the larger building that's on the right. It was originally built to be the residence of President George Washington. But then the Capitol moved to Philadelphia before the building was completed. This was going to be the original White House for the president. So later, many years later, when Jay became governor of the state of New York, this was the residence of the governorship of the governor before the Capitol moved from Manhattan to Albany. This is a photograph of Robert Livingston, John Jay's college classmate and law partner. During the second time that John Jay ran for governor, when he won, his opponent was Robert Livingston. They were fast, furious friends when they were young. They developed very, very serious political differences later in life when they were older. John Jay ran for the Federalists, Livingston ran for the Anti-Federalists, known in those days as the Democrat-Republicans, and John Jay was the victor in that election. Fulton had a hand in the Declaration of Independence. Livingston had a hand in the Declaration of Independence, and he was also an investor on the first Robert Fulton steamship that sailed on the Hudson River. And I think maybe just one more. No, the wrong one. This is the John Jay homestead in Katona, New York, on the 600 acres that Jay originally owned in Westchester, and that's where he spent most of his adult life, and certainly the last portions of his life. When the United Nations was being formed after World War II, they needed a place for a headquarters, and different locations were scouted out, and the acreage of the John Jay homestead was one of the areas that they considered to be the headquarters for the United Nations. Now, for reasons I don't know, they decided not to go with this location, and they instead built that building that stands today on the east side of Manhattan. But Jay, in his retirement, spent his years as a gentleman farmer. Apples, pears, the fruits. It wasn't an animal farm. He stayed out of politics upon his retirement. The only exception was when the Missouri Compromise was being debated. He wrote a letter to a newspaper, and he said we should agree to nothing that would allow any more slave states. The Missouri Compromise allowed for an equal number of slave states and non-slave states to come into the Union. When he was governor of New York during his second term, he enacted some very, very forward-thinking legislation in New York where slavery was abolished over time, depending on the age of the persons involved. No other states had it. He wasn't able to get through laws that would abolish slavery right off the bat all at once. There just wasn't enough support from that in the state legislature. But the compromise that they could reach was to abolish it gradually over time. That law went into effect in 1799, which obviously is a couple of generations ahead of the Civil War. So that's how forward-thinking it was at the time. So I'll answer any questions that anyone might have about John Jay and his life and career. Yes, sir. What's your name?
Fred Howard.
Nice to meet you.
In reading the opinions, the 6 opinions that you described, do you have any sense in those opinions about the political tendencies and philosophies that have later emerged in the Supreme Court, like originalism, or progressivism, or conservatism?
Funny that you mention that, because have you read this book?
No.
Oh, okay, because I addressed that very question.
Okay.
Back in the
Good reason to buy it.
back in the 1700s, late 1700s, and all of the 1800s, and into the early 1900s, The only political philosophy there was originalism. The idea of the Constitution being a living, breathing document that could adapt to changing times, that didn't come up academically until around the time of Woodrow Wilson, and courts didn't start buying into it until maybe the 1960s. So all the judges were originalists when John Jay was a judge. And there's really two sub-schools of originalism. There's some believe in plain language, also known as textualism, and that was the Antonin Scalia theory of originalism. And then other originalists believe in founders' intent. And usually the intent of the founders is the same thing as the plain language, because they have an intent, they have a thought, they write it down, and there it is. But there was one case, and we won't have time tonight to go into it, but there was one case that John Jay handled at the United States Supreme Court where the intent was one thing about whether states could be sued in federal courts, and the plain language said something else. They went with the plain language version of originalism, and it was so unpopular, that decision, which allowed states to be sued, that it resulted in the 11th Amendment to the Constitution. Any other questions? And what's your name?
My name is.
Nice to meet you too.
My name is
okay.
Natalia.
What's your name?
Natalia.
Isai?
Do you know how Sarah Livingston Jay died? Or
Well, back in those days, medical science wasn't exactly what it is today. So it might have been something pancreatic, but we're not sure. Yes?
Hi, Nan Greenwood,
Hi,
and
Nan.
I'm just wondering how many languages he spoke.
I've never
Since you
Heard
said he
that
went to
question?
Spain, he went to France.
Yeah, they always used translators, I know, when he was around. I'm not aware that he spoke any other languages. He might have, actually, I take that back. He was taught Latin when he was in college. I don't know how useful Latin was when he was negotiating with people in Spain, you know, but Latin is, and I don't know how efficient he was at it, but he was taught Latin.
He was taught Latin at home, too.
Yes.
He was homeschooled
Yes,
at that time.
yes.
So,
And your name is
Vicki Contino.
Vicky?
So before the program started, I was Googling a little bit about John Jay, so these sources or whatever they are. But several of the sites seem to say that he was sort of a Federalist light in that he believed that there should remain some sort of dependence on Britain or some sort of relationship with Britain. And so I'm trying to square that, if any of that is at all true in your research, with the fact that he was chosen so many times to represent the United States interests. If that was very common, perhaps, at that time anyway, or not even true.
I wouldn't say he was Federalist light. I think he was down with the Federalists in every way. Not in a way that any of them were extremists, but he was definitely a Federalist in his views. And you mentioned in your question that he had always been asked to do things. I think part of the reason for that was that he was considered to be so good at whatever he was asked to do and so dependable in getting the job done. He left the Supreme Court during his final year on the bench. He was asked by President Washington to go negotiate what we know as the Jay Treaty. And that wasn't anything he wanted to do. It was a year away from his family, negotiating that. And when he came back from the Jay Treaty, he found out he had been elected governor of New York. And he didn't even ask to do that. But once again, he stepped up. He said, okay, I'm elected, I'll do it. And it stopped his travel around the country, so I guess that was one benefit for him. But that's another example of where people ask him to do something and he does it.
It's very hard to square with what we know now. I feel like his father is a part of it. Like, how does that even happen?
Yeah. And the other thing that I had failed to mention, because I started off talking about John Jay High School, is when he was running that intelligence organization, he moved from the city to Fishkill for safety reasons. They thought he and his family would be safer living in Fishkill, and it was in that area where John Jay High School is now, that's where he was living. And that's another connection that he had to Dutchess County, not just cases that he had as an attorney. Thank you for your question.
Thank you.
Yes?
Linda,
Hi, Lynn.
is your book available?
Oh, yeah, it's on audiobooks, it's on Amazon, it's anywhere, Barnes and Noble, it's anywhere.
Do we have a copy here in the library?
No, I can give you a copy, I'd love to donate one to you.
Good,
Okay,
thank you.
you're welcome.
John Jay was involved in pretty much everything throughout the 1770s and 1780s and 1790s. But I just wanted to mention, maybe ask about what I think is probably the single most important event that ever took place in Dutchess County, which was the Constitutional Ratifying Convention that took place at the old courthouse in Poughkeepsie. Jay was involved in that. I'm not sure if he was a formal delegate or if he was there as like a kind of lobbyist essentially for the pro-ratification side. I don't know if that's something that you could talk about, his role there, kind of sway votes in favor of ratification. Just because it was, you know, when that ratifying convention started, I mean, there was massive opposition to the Constitution in New York. And really through the debates at that convention and some external developments that were happening in other states at the time, New York gets on board and ratifies the Constitution. And, you know, that wasn't a foregone conclusion.
No, and in fact, ratification of the Constitution in New York was probably an underdog position originally. A lot of people were opposed to it. The states liked their independence, and they didn't want to have an uber lord over them in a federal capital. Jay was very much in favor of the Constitution, not just in terms of the Federalist Papers, but he was lobbying very hard. I also don't think he was a delegate per se, but he was lobbying very hard and involved with the efforts to pass the Constitution. The original Dutchess County Courthouse was where the Constitutional Convention was being held for the state of New York at the time. And one person that was involved, very involved and very influential and very opposed to the Constitution, as you probably know, was Governor George Clinton, who was an anti-federalist. And Clinton was able to whip up a lot of support for not supporting the Constitution. What I think ultimately resulted in the Constitutionalists getting the upper hand and winning the vote by a very slim margin, I forget the exact number, but it was like 31 to 29, was that you needed a certain number of states to ratify the federal Constitution for it to be deemed effective. I think it was 9 states. And by the time New York did its vote, the 9th state had already voted, and the Constitution was in effect. So at that point, the state of New York really didn't have much to lose and said, okay, we're in with those guys. And they voted that way.
Any other questions? Yeah.
Yes?
My name is Patience.
Patience.
I was wondering, at any time in Jay's later years, did he ever comment or have a change of heart on the case between the Phillips and the Indians?
Not that I am aware of. I can tell you that in his life, his career, his nature, he was never in favor of violence. Not talking about the war, you know, wars happened, but in terms of things like rent riots that arose out of what you're talking about, Phillips or no Phillips, he would never have approved of any kind of violence. He was, in fact, throughout his life, particularly as a judge and as a diplomat abroad, he was very much a conciliator, a negotiator. We look at all the issues and debates that are happening in our country today and how polarized things seem to be between this side and that side. That wasn't John Jay. John Jay's nature was to try to bring people together. And again, we didn't have time to talk about it tonight, but there were a lot of cases in the Supreme Court where different judges would have different opinions. And John Jay was somebody who managed to bring people together. There was hardly ever anybody dissenting on an opinion during the years that John Jay was chief judge. Once John Jay went abroad to negotiate the Jay Treaty, all of a sudden the Supreme Court fell apart. They lost their consensus, and you'd have all sorts of judges going in all sorts of different directions on the cases.
And you mentioned, Mark, his support for the gradual emancipation law in New York, and correct me if I'm wrong here, but I think his son became a fairly prominent abolitionist and really like a financial backer
Yes.
of abolitionism in the years before the Civil War. So he wasn't someone who was like necessarily front and center writing, you know, in newspapers, but he was someone who was financing a lot of abolitionist activity, like in the 1830s or 1840s or something like that, right?
Yes, William was the son, and he devoted much of his career to the cause of abolition. But I think a lot of credit for that goes back to his father, John Jay, because John formed a manumission society in New York, and he had been president of that for some time. They would lobby. They would try to help people that escaped from other places. And he resigned from the Manumission Society upon becoming Chief Judge of the United States Supreme Court so that he wouldn't have an obvious conflict of interest if any slavery-related case ever came up to him. He was thinking ahead. Now, he never had a slavery-related case when he was Chief Judge, but I think it's very clear that if he had one, he would have had a certain point of view on the issue, the way he had a certain point of view about creditors versus debtors. You know, he would have had that point of view on any slavery issue that came before him.
I just want to mention two things before we run out of time. Next month's program, February 16th, is about a stained glass window and the restoration of a stained glass window in a church across the street. We're having Father Matt from the church and an expert on stained glass who was involved in researching it and restoring it come and talk to us. And I made brownies. If you'd like a brownie before you go. I will say that I think they're blondie. I put too much chocolate in them. They're about 80% chocolate. So if you like chocolate,
That's good.
almost all of them. Let us thank Mark for this talk. It's terrific. I'm sure if you have more questions for him, I'm sure he'll answer.
I'll stick
But
around.
yeah, thank you for coming, everybody. Appreciate it. Rob. Oh, yes, thank you. You too. Back here.